Good afternoon.
Good afternoon.
Good afternoon.
Good afternoon.
Good afternoon.
Everybody is bright and early and on time and ready to go. Am I correct?
Yes.
Okay. Okay, so let's start then. We're going to do chapter 2, understanding the conveyancing process. So we know we have some experts who are in charge of documents. And so this section should be quite familiar to them. If not, you're free to ask any questions. So the first thing is when you're talking about purchasing a piece of property, you know that in order for the title to be transferred from one person to another, it actually is called a conveyance. So we're going to go through the process of if you own a piece of property in fee simple absolute in possession, and now you wish to sell it to another person, what is that process? So the first thing you have is you have to have a contract between buyer and seller. And following the law of contract, it means you must have an offer, you must have acceptance, you must have consideration. That means that money must pass or an action must pass between both parties. You must have legal considerations and an intention to create a legal arrangement, which means that both persons must be of the same mind. So you cannot have the buyer saying, oh, I'm not too sure I want to purchase now, but I'll enter the contract anyhow. No. Both parties must be of the same mind that they both intend one to sell and one to purchase. And of course, it means that it has to have the terms and conditions. What is the purchaser's responsibility and what is the vendor's responsibility? So the first thing you need to do is prepare a contract. And so the parties to the contract are the vendor, the purchaser, the real estate agent if one is involved, and of course, the respective parties' attorneys. In some instances, you have one attorney dealing with both the vendor and the purchaser. So the next step after you come to an agreement that you want to enter into a contract to either to sell or to purchase the property is you have to now have an approval of the contract. That's the agreement for sale process. And here you set out all of your terms and conditions. You put your purchase price, the deposit you require, when you expect the completion date for the sale, usually it's 3 months. And then the obligation on the seller, which is that he has to prove that he has good and marketable title. So what does good and marketable title mean? If you were selling a piece of property, what does it mean to have good and marketable title?
It means that there's no judgment on the property. You own the property outright. Be absolute simple. There's no judgments on the property or no liens or anything else on it.
Correct. Yes. So it means that you own that property in fee simple absolute in possession, and there are no judgments against that property. That's what means good and marketable title. So if you have a good and marketable title, then you are free then to enter into the contract for the sale of the property. And of course, like in any contract, there has to be consequences. So if the vendor is unable to give you a good and marketable title, you have to have whatever the consequences are. And also if the purchaser fails to obtain financing, which is if they're going to the bank for a loan within a specified period, then of course the contract will be canceled. So the next step is you have to exchange of the contracts. So you have to make your deposit because you're the purchaser, which is usually 10%. And that's paid to the vendor's attorney. at the date of the execution of the agreement for sale and is held in escrow. I know a lot of people have horror stories in terms of making a down payment, finding out that it's the wrong property, finding out that the people have disappeared. There's lots of horror stories. So your next step is you have to deduce title. That means that the vendor has to prove, or he has to provide the receipt of the original copies of his title documents. And the abstract of the title covers a period of a time fixed in the contract. And normally it's commonplace for the vendor to deduce his title before the exchange of contracts, which means that you want to see the title prior to, just to ensure that he does have a good and marketable title before you start to incur all of this expense. So after you deduce title, you have the investigation of title. So now you move. Go ahead.
Before you go any further,
Go ahead.
the abstract of title covers a period of time fixed by the contract. What,
Mhm.
go into a little bit more detail for me. How does that tie to the 30-year root title? Is that the same, or the abstract of the title covers a period of time fixed by the contract? What does that mean?
How many days they have in order to produce this abstract of title?
Okay.
Yeah. What you're talking about is when you do the investigation of title.
Right. I just was wondering if
Right,
this was the same thing.
Okay, by the
Okay, so this is
purchaser.
really just to say that the vendor has a month or 6 weeks to
14
produce a good
days,
title.
whatever
14.
number of days, yeah.
Okay.
So the investigation of title. So the purchaser's attorney now, it's time for them to investigate the title to the property. And they have to do this title search. And of course, go check the Supreme Court list to see if there's any judgments by any previous owner of the property. Now remember, I told you that we have unregistered land. So if you're in a registered jurisdiction, all of this is a press of a button. It does not take long. And then the attorney will confirm whether or not he has a proper chain of title. Now the chain of title goes from no more than 30 years. So when you start doing your research, your period goes back as far as there has been a grant or a lease by the government or a certificate that was granted in the quieting, or you go back as far as 30 years. So it's one of the three. Whichever one is shorter, that is how far you go. The attorney also have to make sure that there are no outstanding amounts for real property tax, anything on your light bill, your water bill, whether there's any fees or dues you owe, if you're in one of those gated community or condominium. And of course, if it is a non-Bohemian, they have to make sure that the application is put into the Bahamas Investment Authority. Now, the purchaser doing his research may have, the purchaser's attorney may have some questions. And these are what you call requisitions. So they may have some questions on the title, or they may see things that they're querying. Sometimes an area may have been zoned for a particular purpose a long time ago, and now it's being rezoned, but they cannot find where the approval was granted. They may ask for a copy of that. There may have been when one of the purchasers, the owners of the land before, had some restrictions with the land, and they no longer see those. So they have different queries that they can ask. And it's now up to the vendor's attorney to provide responses. And normally the information regarding whether or not you have questions or inquiries is normally done in a 14-day period between receipt of the documents. So when you get your documents and you start your research, you have 14 days to ask whatever queries that you may foresee. with respect to the land. You could also ask questions about whether the subdivision, there have been any changes or any changes to come, whether there's any rezoning, when was the latest real property tax assessment, whether there was any current survey of the property, whether there's any government proposals to acquire land, or whether there's any right of way or restrictive covenants or easements. So all of these queries you can ask the vendor's attorney. So until you, as the purchaser's attorney, is satisfied and that you have all the answers you want, once you have all of the answers, then you could prepare your report of opinion on the title. And you can send that report of opinion to the lending institution. So for those who work in this department, you should be familiar with that report on opinion. And I know we've had in the past 8 years, a lot of attorneys who have prepared these report on opinion and they were false. So I know you could recall some of them that went before the court and before the Bar Association. Any memories going back that far?
Lots.
Okay. So now you see there is a process. So once all inquiries are done, you've done all of your checks for see if there's any outstanding bills. You prepared your opinion on title, then it's time to draft the conveyance. And that's normally done by the vendor's attorney. And it's reviewed by both parties. The conveyance includes your name, your address, any reference on any earlier titles, the description of the property, whether there's any restrictive covenants or easements or rights of way. And that's why it's so important that the purchaser's attorney check to see if these things are still relevant and that they actually run with the property. You have a plan of the property. And of course, any affidavits that you need in support of the conveyance. So the next stage is the final stage, which is the completion. So once the conveyance is finalized by the vendor's attorney, executed by the vendor and the purchaser, their signatures have to be witnessed. Remember, whenever you transfer property, it has to be written and it has to be by deed in order to comply with the legal requirement to circumvent fraud. So a completion statement is prepared by the vendor's attorney and the balance of the purchase price is paid, less the vendor's portion of stamp duty and any apportionment of the other bills, such as real property, assessments, and utilities, whatever else is outstanding. Remember that these can be agreed between the vendor and the purchaser. The vendor's attorney may forward the title documents to the purchaser's attorney in escrow, pending final payment of the purchase price. The legal fees will range from 1.5% to 2.5%, and they're paid on or before the completion by the vendor and the purchaser to their attorneys. The real estate agents are paid the same time. Any requests to the utility companies for return of deposits to the vendors and all utilities, real property tax assessments are placed in the purchaser's name. So once the purchase price, the balance is being paid to the vendor's attorney, subject to the completion statement, and the vendor attorney acknowledges receipt of payment, the property transaction is complete. Then the conveyance is sent for stamping to the public treasury. The stamp duty is paid on a conveyance, which is normally split between the vendor and the purchaser. And of course, it's based on the total consideration or purchase price of the property. When we go further down, you'll also hear how the VAT controller, he now has the right, even though you may have a consideration, the purchase price on the property, he now has the authority to go and check any other property that was sold within that vicinity to see if the price that you've quoted on your conveyance is the right price for a piece of property. He has that right in law. Now, if non-Bahamians are purchasing property,
I can't get
Yes.
in. I can't hear nothing. What am I doing wrong?
You have a headset or something?
No, I was trying to use my laptop, but I still need a headset. Let me try that. But nobody has their camera on, right?
no. You still can't hear? Can you hear now? Can you hear? Can I continue?
I guess it looks like she has two devices connected.
Oh,
That's how it looks.
I guess we'll do
I think she's having problem hearing.
Mhm.
I'm not sure. I told her to try to use the headset and maybe she'll hear us because that's how I'm able to hear. I'm not able to hear if I don't use my headset. So I tell
okay.
her to try that and then
She
So
might
I
have to
guess-
listen to the recording after.
yeah, I
Yeah,
told her that.
should have listened to the recording, yeah. Okay, so,
Okay.
you know, non-Bahamians love to come to the Bahamas to purchase property. And you know, they do so under the International Persons Landholding Act. So normally, the lawyers normally proposition non-Bahamians, first thing to do, incorporate an IBC. And they incorporate an IBC to hold the property that they're going to purchase. So it becomes an investment for them. And you know that when you use an IBC for this purpose, you have that confidentiality. You know you have limited liability. And of course, you have anonymity because the company has its own name. So being a company can sue and be sued. And once you're transacting business, unless it's dealing with a bank, normally is the name of the company that is seen on all the documents and not the name of the beneficial owner. So under the International Persons Landholding Act, a non-Bahamian has to register their purchase with the Bahamas Investment Authority, and they have to obtain a certificate of registration. Otherwise, a permit from the investment board prior to their purchase. A certificate of registration is not only required for vacant and non-vacant property, but also for condominiums under 2 acres or property under 2 acres. They'll be used as owner-occupied property. A permit is, go ahead. She's coming in now. That was a lot of static just now.
Dropped off.
Yeah. Okay, so if you're purchasing more than two or more contiguous acres and as a non-Bahamian, you need a permit. Or you're going to rent out or all or portion of the property, or where the property is to be used for commercial purposes, you need a permit. A non-Bahamian must obtain a permit for any subsequent purchase of property. Now, a permanent residence, they are required to register their purchase of property, whether it's vacant or non-vacant, but they're not required to obtain a permit. Now, a non-Bahamian lender, so that means a non-Bahamian bank or financial institution that acquires a security that is in the Bahamas, a property is in the Bahamas, they need exchange control approval to hold such property. In the event that the person defaults, because then the financial institution will have the property up for sale. And so the exchange control needs to know who the beneficial owner of the property will be after the sale. And that duty then is placed on that financial institution. And of course, they have to get a permit from the Bahamas Investment Board. So we know when, go ahead.
Sorry, what if the purchaser didn't use a bank, like a local bank, like they had some funds sitting around somewhere, so they just decided to purchase a property? What happens in that case?
You mean a non-Bahamian?
Yeah, so non-Bahamian.
Well, if it's a lender, then they would have actually purchased, normally when you're purchasing property in the Bahamas, and it's a large property, most of the time, because it is an investment, they normally go through the Bahamas Investment Authority, especially when you want to sell it later.
Okay,
Yeah,
thanks.
that's the only way the government can keep a track of who owns the property. So you know, we don't have direct tax. We have indirect tax. And real property is taxed. So let's look at stamp exemptions. And this act is amended very often. So under the amendment in 2008, we know that anybody, first time owners of a house, valued at $500,000 or less, they are exempted from stamp duty. So after stamping, the title document is sent for recording at the Registry of Deeds and Documents for a nominal recording fee, very small. Then they did an amendment in 2010. And under this amendment in the Stamp Act, it said the stamp duty that is enforced at the date the documents or transactions are presented for stamping, not the date when the transaction was completed for the document was drafted. So this was just a technicality as to when you have to pay the stamp duty. It also said that stamp duty will now be paid on the greater amount of the purchase price or the market value of the property, as evidenced by an appraisal, by an approved appraiser. So they don't go just by the purchase price or the consideration, they go by whatever is the market value of the property, whichever is higher of the two, and based on the approved appraiser. And if you notice now the list of appraisers, those who have obtained their license through the Department of Inland Revenue, they're actually published. So an amendment also extends the definition of mortgage to include any promissory note that is made supplemental to or in connection with any mortgage or charge. So stamp duty is also required to be paid on the combined consideration where there's property transaction involving a transfer of land and a construction contract. Transfers of property from one individual to a company, all of whose shares are beneficially owned by that individual, and transfers of property from an individual to the trustees of a trust or a class of persons, which is unalterably limited to that same individual, his spouse or children or other issue, they are exempt from the payment of stamp duty. The treasurer may stamp any unstamped or insufficiently stamped instrument after execution, provided the payment of the unpaid stamp duty and a surcharge of 10%. Whereas 6 months or more has elapsed from the date of the execution of the document. Now, when you have disputed land, the treasurer takes into consideration the value of any adjoining property that's in dispute to the property that you actually wanting to be registered and stamped. So they'll look at an adjoining property to see what was the value on that piece of property, anything that's sold within 12 months. And they determine the liability for the payment of stamp duty of the disputed property. In 2018, they did further amendments again, and now they levy a 2.5 stamp duty on the value of a deed of conveyance, an assignment or a transfer of real property at $100,000 and under, and then stamp duty is 10% of the value in excess of 100,000. Stamp duty of 2.5% of the value of interest in real property is levied on a transactional instrument, which is treated as a transfer of land, which has the effect of transferring an interest in real property by virtue of the transfer of issued shares or the beneficial ownership interest of a company which owns real property in the Bahamas. Stamp duty of $10 is payable on a deed of rectification and confirmatory conveyance. So that's normally just for clerical errors, or there's just some amendment to be done to the description of the property.
Ms. Archer, has there been any amendments to the 2018 Act?
Stamp Act?
Yes.
Let me see. I know they did the VAT in 2020. Hold on. I just had them here. VAT change in 2020. The Stamp Act change in 2020 also. They had some amendments. It really seemed to do with the fees. What exactly you were looking for?
The conveyance, where it says the amendment, the 2018 Amendment Act, 2.5 stamp duty on the value of the deed of conveyance. Are they charging VAT on that, or is it 2.5 stamp and what? I mean, how are they doing it now?
That's a tricky question because it came from tricky people. Hold on. No, because the way it is worded is so complicated. Hold on. Let's finish this and then we're gonna look at how they set it out, how it's supposed to be paid. And it'll be a little clearer then. Hold your question.
Okay.
Hold your question. Okay, so that's the 218. So it says, where transfer of mortgage and further advances made by new licensed lending institution, stamp duty is only payable in the further sums advanced. So you know, in the last, 6 years, all of the banks have been competing for mortgages. People have been moving mortgage from here, there, and all over the place, trying to get the lowest rate possible. So that question was raised then as to whether you had to pay stamp duty as you move from bank to bank. So they said, no, it's only when there's a further sum advanced. So they said, where there is a transfer of mortgage, and that includes where a mortgage is satisfied by one lending institution, and then you get a new mortgage to another institution, but is on the same property, the instrument that evidences satisfaction of the subsisting mortgage and the creation of the new mortgage is exempt from stamp duty. So under the Stamp Act, the treasurer may stamp an application for the exemption of stamp duty on any instrument made pursuant to provisions of the Stamp Act 2002 and the amendment in 2008. Where approval for the exemption had been previously granted, or where the title document to whom the application refers remains unstamped. And of course, that's subject to the payment of surcharge and evidence of approval that you are exempted. But that's stamp tax. So we'll come back to stamp tax when we look at the exercise. Next tax on property is VAT. So under the VAT real estate rules, you know that VAT is charged on all conveyances valued over 100,000. Anything that's under is exempt. In determining the amount that's chargeable on conveyances, what the controller does is he considers the purchase price, like I said before, the appraisal value, and of course, he is allowed to choose the higher value of the two. Property transactions over 100,000 now attract the same duty as stamp duty, a rate of 2.5% for 100,000 and 10% for over 100,000. The purchaser and the vendor may decide to split both the stamp duty and the VAT 50-50, depending upon their negotiation agreement when they decide to enter into their contract. The VAT rules allow a purchaser does not allow a purchaser as a VAT registrant to claim their VAT payment as an input credit if the property is exempt from the payment of VAT. For closing costs, VAT is normally paid to the VAT controller and is based upon the determination of the VAT to be paid on the property transaction. The VAT controller can also request that an appraisal report be submitted that reflects the true market value of the property if he is not satisfied that the consideration amount listed on the conveyance is the true amount. After the payment of VAT, the relevant stamp duty of 2.5% is paid to the public treasury. And of course, then the title documents are sent to the Registry of Deeds and records for stamping and recording. So under the rules, VAT is charged on related professional service
We can't hear you.
are also exempt from the payment of VAT.
You ran out just now.
I did?
Yeah.
From where?
I can't remember now. VAT is. Anybody else know?
The last thing I heard was that VAT is charged on related professional services, like legal services, appraisals. That was the last thing I heard.
Okay, you ain't missed much. I said first-time homeowners who are exempt from the payment of stamp duty are also exempt from the payment of VAT. Rental of residential properties, transfer of vacant land are also exempt from the payment of VAT. Now, in the VAT Amendment 2019, they created inserted a new section, and there's liability to pay VAT on inter vivos gifts. So any person who within 7 years of receiving an inter vivos gift of real property, and they make a further supply of that real property to any other person who is not their spouse, their parent, their child, or some remote issue of theirs, or other than a security under a mortgage made or granted by a financial institution regulated by the Banks and Trust Company Regulations Act, they have to pay VAT on such gift. The gifts are no longer free. All right, so now let's look at it. Standard fees. Normally, stamp duty is nil. VAT, if the property is up to 100,000, you pay 2.5%. Over, you pay 10%. You have to pay the real estate agent fees. If it's vacant land, is 10%. Non-vacant, 6%, plus VAT. You have to pay the attorney fees, which is 2.5%. Then if it's a non-Bahamian, you have to pay the Bahamas Investment Board fees, $250 for registration, $500 for the permit. Then you have to pay real property taxes. And for real property tax, there's no VAT paid on top of that because that's already a tax. So owner occupied property has increased from 50,000 to 60,000 per year. And of course, you know, they are doing the assessments on properties by drone. So owner occupied property, 250 and under is nil. 250 to $500,000 is 0.625. $500,000 to $5 million is 1%. And then over 5 million is 0.25%. Now, there are certain exemptions are made for first-time owners and Bahamian owner of vacant or non-vacant land in the family island and vacant land generally. So when a non-Bahamian owns vacant land, the first 7,000 is 100, 7 to 75,000 is 1.5, 75,000 to 500,000 is 0.75, and over 500,000 is 2%.
So I have a question.
Mm-hmm.
Owner occupied property, that's just the building of the property. That doesn't include the amount of the land. Meaning that they don't incorporate what you paid for the land as well as what you would have built, use the money to build the land.
No, but when you get the appraisal, the appraisal includes all of that.
If you didn't have property on, if you didn't have a building on the property itself and you just paid for the land, it's less than, let's say if it's 100,000, and then I build on it. Am I paying I'm paying real property tax on the calculation of the land as well as me building?
Mm-hmm. What's the market value? Yes, the whole thing.
Okay. Thank you.
Mm-hmm. Wait till income tax comes. Appraisal. Of course, appraisal fees is, well, what they have here is kind of low. 350 to 500. Some people charge much more than that. Depends on what all you want in the appraisal. So it depends on the scope. You can negotiate a price that you want. So 350 is kind of low. So that's probably for a small house. Some institute. Go ahead.
Sorry, you might have gone to answer my question, but my question was, why is it that some institutions require certain things from appraisers? Because if you would go to appraiser and have person say that they'll ask for which institution is for, so it's a different calculation based on the institution. Is that, why is that?
When you say different calculation, what you mean?
Like not calculation, but approach. I think some is like a cost-based approach, and some is like, I don't remember the exact terminology that they use.
So all right. So when you look at each financial institution, you have to think of it not as them just lending you money. From the institution point of view, they have to look at the risk. And so they would have established their credit risk policy based upon the risk. And they would have already assessed what their formula is in the event that there is a default. So what they're looking for is that built-in factor that they have already calculated. In the event there is a default, these are their multipliers. And every institution is different.
Okay,
So
Right.
that's because I know most people, when they're looking for a mortgage, they're just looking for who has the lowest interest rate.
correct.
Right. But there's more to it than that. Because there's
Yes.
some institutions you will not qualify, period.
Mm-hmm. Mm-hmm.
And some actually will tell you that I think you building a house outside of your earning capacity right off the top,
Mm-hmm.
because they're using a different multiplier from another bank.
Yep.
Yeah, I experienced that, but I always found that to be strange seeing that. But I understand how you said that because of
Yeah.
it depends on the risk appetite of the institution.
Yes, right.
Okay, that's
Mhm.
fair.
Right. So yes, they offer mortgages, but they have a different multiplier. Each one is different, looking at the risk. And if you look at the past couple of years, when all of those homes had to be put up for sale, then you could see why it's even harder now to get a mortgage. Even though they're advertising heavily, it's very hard for people to qualify.
Hello, Ms. Archer. Can I just interject as
Mhm.
well?
Go ahead.
From my experience too with dealing with appraisers, I guess the institute also looks at, because they do like Lindira said, they do like a different approach. I think it's like the cost approach, the comparable approach, and I think it's income approach. So it depends on the actual property, because if like it's a duplex, they would lean more towards maybe the income approach. If they're looking at, I guess, foreclosure, they want to look at the market. So they look at the comparables, because the cost to build something cost varies year over year. It changes.
Mhm.
But the market may be seeing something else. When you look at comparables, you may not be able to get the cost. It may be lower or it may be higher. So they want all those approaches from the appraisers so they could do their own analysis.
Mhm. Mhm.
That's from my
Okay.
Yeah.
experience with dealing with appraisers, because I
Yeah.
guess my interaction with the appraiser and dealing with it on the buying side, they look at like you said, the bank looks at their risk factors,
Mhm.
because the appraiser may come to a conclusion which the bank may not agree to. They may say, well, this property maybe be valued more than that, or I don't really agree with what value you're giving us. Maybe we should use, because they give various values in the appraisal, and then they come to a conclusion to say, well, this property is valued whatever amount. But the bank may go ahead and use one of the other valuations that you gave within that appraisal. So it's
Right.
like you say, it's various factors that they look at from a bank's perspective in looking at an appraisal.
Mhm. And then if you look at it now, if you add the pandemic with the hurricane, I would think they also look at your borrowing capacity. Are you in one of those industries where soon as someone sneezes, you're out of a job? Or are you in one of those industries where you'll always more or less have a job, no matter what? All of those are risk factors. Do we really want to take on this loan if we know that if somebody sneezes, this person is out of a job? Then you're back to having a huge portfolio of buildings to be sold. And then you have to sell them at a loss. So yes, it is very difficult now to get a home. It is difficult. And of course, if you're the purchaser, you have to pay for the appraisal. So the title search will run you to about $350 or more plus VAT. The recording fees is $450 per page. For mortgages, I don't know if the rates have changed. The bank service fee is 2.5%. It's still 2.5. Normally
It
based
could,
Yes,
upon
it,
the
from-
it could, it could go as low as 1%, I think, in some cases where they're trying to negotiate or get a client to come over.
Oh, okay.
Yeah, and it also depends again on the risk appetite as well.
Mm-hmm. Stamp duty, 1%. Satisfaction of the mortgage, 1%. And of course, the recording fee is $450. Now, in the VAT rules in 2019, I just told you earlier where it said that if you were to transfer into Vivos a gift and is not one of your direct relatives, you have to pay VAT. So in the reverse, it says these are the persons or these are the transactions that are exempt from VAT. Real property, if there's no change in the beneficial owner, you don't pay any VAT. If the transferee is your spouse, your parents, your children, or any remote issues, you don't pay any VAT. If the transferees are as a company and all the shares and every class are beneficially owned by the transferor, so that means it's the same person, then you don't pay any VAT. If the transferees are a trustee and where the express and unalterable terms of the trust instrument exclude the trustee from taking or receiving any title, then it's exempt. If it is a foundation where the only beneficiaries are the founder or the founder's spouse, parents, children, or remote issue, it's exempt. If there's a gift or real property from one exclusive charitable or religious or nonprofit institution to another one, it's exempt. Any real property transfer that's made pursuant to an order under the Matrimonial Causes Act, which means like in the divorce proceedings, those are exempt. Any acquisition of a dwelling for the first time by a Bahamian, where the value does not exceed $500,000. If there's a transfer between two licensed institutions for mortgage, is exempt. And where the transaction of real property under death or bankruptcy of the owner of any property to their personal representative or trustee in bankruptcy, it's exempt. So you notice how the rules have been set now. Anything that's being transferred and it's in the familial line, then you don't pay. As long as you go outside of that family, you will have to pay VAT. Now, remember last class, we spoke about leases. And what was a lease? What did we say a lease was? A lot of people have leases. Remember, it's a contract between a landlord and a tenant. Right. And it's for a certain period of time. So normally in it, there are certain characteristics that make a lease valid. Not that there is a lease, but makes the lease valid. So the first thing is the tenant must have the right to exclusive possession. What does that mean? We spoke about that last class.
Where they have physical control over the property, but they
Yes.
don't have rights. I mean, they don't have the title or rights to it.
Right. So they have the key. They can come into their premises. They have the right to walk around their premises. Make sure they follow the terms and conditions. Remember, I was saying you can't just go and paint a wall blue if that's one of the things that's in there. So if the person granting the lease remains in control, which means that the landlord could come in and go in and out as he pleases, there is no tenancy. So that's the first thing. You must have exclusive possession in order for there to be a tenancy. Now, the next thing is a lease cannot be for an uncertain period. So, you know, when you rent in a premises, you always have to say it's for monthly, it's for quarterly, it's annually. Those are the terms. And the terms have to be expressly stated. So it can be for an uncertain time. And then, of course, the lease has to be created in a proper manner, which means it has to be in writing, or it has to be by deed if it is a legal estate.
I have a question when you finish. It's about joint tenancy and tenancy in common.
Okay, let me finish then.
Yeah.
Okay, all right. So the next thing is, what are the types of commercial leases? A lease could be granted for a fixed period of certain duration, short term or long term. And remember what I said before with leases. If I lease the property from you for 20 years, I cannot sublease it for 25 years. It cannot go over the period of my lease. Always remember that. So both the commencement and the duration of the term of the lease must either be certain or be rendered certain before the lease takes effect. The next thing about commercial leases is normally leases are yearly. That means they're year to year. But of course, you know that they can be monthly and they can be quarterly. And normally it's terminated by notice. So even though the landlord may have died, the contract is still in existence. You could actually have a tenancy by implication. So this is where a person occupies with the owner's consent, and it was intended that they would pay rent, unless there's some kind of different intention that is actually agreed between the two parties. So you could have an agreement for tenancy, either express, which is written, or by inference. And a tenancy at will is where there is a tenant with the consent of the landlord. They occupy the premise on the term that either party may terminate the tenancy at any time. And is normally, unless it's otherwise, is rent-free. Even though the landlord is entitled to some kind of compensation for use and occupation of premises. And the tenancy will terminate when either the landlord or the tenant does any act that is outside the continuance of the tenancy. So they could either just verbally agree that they're going to terminate it. So in a commercial lease, there's the usual relevant provisions in it. They always have the rights and the duties, responsibilities and obligations of the landlord and the tenant. The amount to be paid, the frequency, where it should be paid. Where there are no express terms and conditions, there are always what we call implied covenants. And those implied covenants are founded in common law and is based on what is general in terms of lease. So one of the most important thing that goes with landlord and tenancy and in leases is that implied covenant of quiet enjoyment, which means that your landlord cannot keep going in and out of your apartment, can come in when he pleases. And the tenant, as long as he is fulfilling his part of the contract, which is he's paying rent, he's making sure that all the commitments are being made on his side, then there's no need for the landlord to be coming in and out of his place. Of course, he will follow the agreement in terms of repairs as to who is responsible for repairs. And then I've listed the stamp duty for commercial leases. So you can see this chapter 2 has a lot of information. So you know at least 3 questions coming from this section. Any other questions?
So, Ms. Archer, question for you. When does
Go ahead.
stamp duty on commercial leases, like when is that paid? And I didn't realize they charge stamp duty on a commercial lease. So if you do a commercial lease, let's say on a building, you have to have that drawn up legally and submitted for stamping and recording as well.
Uh-huh. Mm-hmm.
And it's the stamp tax is paid to government on whatever the lease amount is. So if I'm leasing it for 500,000 for 3 years, I pay on the 500,000.
Yeah, because it's a commercial lease now. This is not a, this is people like who have buildings
Yeah.
and they're renting it as a business.
Okay. All right. Okay, thank you.
The government has to make money somewhere, somehow.
Yeah, that's true. Ms. Archer, the lease, can the term lease be used interchangeably with rental agreement or no?
Now, what you mean?
I mean, not the commercial lease. I'm talking about the regular tenant where the tenant come and live. It's a duplex or something like that. Is the lease term be used interchangeably with the rental agreement?
Not really.
Oh,
No. You normally use the lease for more long-term and more for commercial purposes. So let's say if you have a duplex and someone, you do a contract and they say they must pay you monthly. Yes, they have the same rights in terms of quiet enjoyment and exclusive possession of the property, but the contractual terms are different. So you wanted to see whether or not a commercial lease has the same provisions as a regular one when you rent an apartment?
kind of, sort of.
Mm.
Yeah.
But the difference is when you rent an apartment, in terms of that versus a lease, when you have a lease, if you don't pay, I can put you out today. When you're dealing with an apartment with an individual or a family, you cannot just put them out. So there are some differences.
Okay, but that's the main difference between
Yeah,
them.
yeah, both of
Okay.
exclusive possession, both say you could pay monthly, quarterly, annually, but there is a difference.
Okay, thanks.
Okay. Who had the question on joint tenancy and tenants in common?
That's Pintard.
Oh, okay.
I
Go
have
ahead.
two scenarios, and I guess you could tell me, or this distinguish which one is which.
Okay, go ahead.
My siblings and I willed my father's home on his land, right?
Mm-hmm.
And we are to share it equally. Is it where, if talking about survivorship, if one of them were to pass on, would then the ownership pass on to the survivors? You're saying, right?
Mm-hmm. Yeah.
We won't be able to sell or mortgage it unless all three of us agree. Is that correct?
Yes. Uh-huh.
So the other scenario is where, again, there's like an easement because our grandmother willed it to our mother, who is deceased now, and willed it to us, but it's on the same land, shared between my aunt and uncle. So they have a building and we have a building on the same land, basically. We're not able to sell because it's sitting on the same land.
Mm-hmm.
What relationship would we have with them? Would it pass on now to our kids if one dies? One brother doesn't have any kids. Let me go back to the first scenario.
Yeah.
My
Go
oldest
ahead.
brother, my father's home now on the land. Myself and my brother has moved. If he was to pass, that would then pass on to us, correct?
No, hold on. Start again.
Let's
This is one piece of land. Let's say 25 by 100.
That
Right?
it's my father's home.
No, hold on. Your father got it from his mother.
Correct.
Okay. So it was willed to your father from your mother, from your grandmother.
Correct.
Okay. What did that will say?
Well, he was the only child, first of all.
Okay. All right. So he got it automatically.
Yes.
Okay. All right. So now he has passed.
Correct.
So when your grandmother gave it to him, he owned the whole 125 by 100.
Yes. In fact, his aunt actually gave him her property as well, too. So it's actually two properties in one. But again,
okay, so he got both. Okay.
Yeah.
So on this property now, he has allowed his uncle to build a house there and one himself.
No, it's two different scenarios. I was going back to the first one. The first one is basically, yeah, my father has passed on, but he willed it to two of my siblings and myself, one of which the oldest one is living in the home. He has no kids, right? I want to know if it's joint tenancy or tenancy in common. If he was to pass on, would it then pass down to my other sibling and myself?
Okay, so he has no children and he gave it to the three of you equally.
Correct.
Okay, so when your brother dies, then you and your other sibling share it equally.
Okay. Now the other scenario is.
Right, say the other one now.
Yeah. Same, I guess it's the same land. I think it's the same land, but it's two buildings on it. A home, and then my grandmother would have purchased the other portion to just put a rental, right?
Okay, stop right there.
Let's just say two rental on one land.
Purchase from home.
This is my grandmother's property. Oh, right.
Okay.
She passed on and she willed it to my mother, the senior person, and her siblings, which is two boys and a girl.
So she left it to the mother and the siblings?
My grandmother left it to my mother and her siblings. So my aunt and uncle and my mother.
Oh, I see. Okay. I got you. Okay.
Now that my mother has passed and my mother and father married, of course.
She left it to them equally?
She left it to us and my father equally. My father.
No. Start again. The grandmother
left
it to her three children.
The grandmother left one of the buildings that was one of the buildings to her three kids. My
Right.
mother, being the oldest one of 4 kids, she left her the actual other building, which is the house. So my mother owns one building, and the 3 share the other building.
Got you. Okay.
Right.
Okay.
Now my mother passed. She left it to her children, which is myself and the 2 brothers, and my father. Right.
Mm-hmm. Both, both,
Go ahead.
both of her interests. The one
Yes.
that she owned outright and the one that she has a third, she left it to the children and her husband.
Well, the one that she has a third of with her sibling, she actually doesn't own it with her sibling. She just owned the one by herself. So the grandmother basically had 2 buildings, and she left 3 to take care of one, and the other child to take care of one, which is
And
my
when you
mom.
say take care, what you mean take care?
Will it to them to have.
Okay.
So she doesn't have to share that with anyone. The other siblings will share that building,
Okay. Got
right?
you. Uh-huh.
So now that my he was taking care of it. He passed on. So it now us 3 again taking care of it because it's rented out.
The home.
Yes.
Okay.
Because it sits on one land, I'm thinking like, okay, first of all, what would that be? Would that be joint uh, tenancy when we have to deal with our aunt and uncle because it's on one land?
It depends on how the conveyance itself is worded.
Mm-hmm. Okay.
From
But
when your grandmother got that land, and she created 2 separate buildings on this property owned by, and then she turned around and she divided it into 2 separate ownerships.
You're right.
Thereby creating that easement within that.
Yes.
That easement did not run with that land. That easement has been created.
Mm-hmm.
So it depends on when she put that in her will, how that was worded.
Okay.
Everything depends on the wording, because based upon what you were saying, that easement was created between the 2 lands.
Yes.
So even if you wanted to sell the home, right?
Mm-hmm.
The buyer has to be aware that there is an easement
On it, right.
on that property, which gives your aunts and uncle those the right to go through their property.
Right. I got you. So in the first scenario, that would be a joint tenancy between us 3, the siblings, right? And my father.
Yes.
Okay.
Uh-huh. Mm-hmm.
So would the other one be tenancy in common?
Archer, wouldn't they have to, with the first scenario, wouldn't she have to refer to, if, we talk about tested and intestate, because wouldn't the same thing apply? It depends on how he left it to them.
That's what I was thinking with
Like,
the survivorship, right?
right, like, was it when he died, if he died, testate, what does it say? Tenants
Yeah,
in
what's in the
common,
will?
or
Yeah, what's in the
right?
will?
So you
What's
still
in
have
the
to
will?
refer back to
Yeah.
whatever
Wording in
it
the
was.
will.
The
Mhm.
benefit is that the brother doesn't have any children, and so the next of kin or the estate will probably be the sisters in any event. But I think it still has to go back to whatever the will or the letters of administration say, whether they tenants in common or joint tenants. Because
Mhm.
I don't know that it's automatic that it's joint with the right of survivorship. If he dies or something happens to him, it automatically goes to them. I don't know.
It depends on the wording. See the wording in the will, and it tells you whether or not it's right of survivorship or it's tenancy in common.
Could he say
Everything is the wording.
be sold and it should be shared equally?
Which one? The first scenario?
First scenario.
Yeah, because you said that's what it said. It said to be shared equally.
but not sold. But I'm thinking if we all agree that it could be sold, we can do that. Or
Yeah,
no?
if you all agree. Yeah, if you all agree.
All right. Just some clarity. Thank you.
Yeah, you all have to agree.
Okay.
Now, the other one where you say there's another building on the land where it was your mother and her two siblings,
3 siblings, yeah.
the three siblings.
Mhm.
So she has passed now. So her share then moves down to you all.
Right.
So whatever they want to do with that building, they need to get the consent from her children.
Okay.
And Todd, why y'all don't have it phrased and have it like another conveyance done to split the property?
Mm,
Okay.
dealing with so many persons may not be able to afford to do all that. I mean, we could always take down the fence and do different entrance because really and truly,
One
I
to
don't
the
have,
back and one to the front.
well, both to the front. We could do one on one left side and the next one on the right side, I'm assuming, but I think certain things are shared between, see, I'm not even sure. It might be one water pump or something like that. You see what I mean?
Oh, yeah. So you still have an easement.
Yeah. So I'll have to investigate it more.
But I mean, you can still separate it, like she's saying, and just
Yeah.
create another water pump or whatever it is.
Yeah, I do lot of plot of land, number 55, 55A and 55B.
Yeah, you could do it like that.
Mm. Okay.
That'll eliminate all of y'all headache. Y'all would still have a share in 55B, but you know that 55A is straight out.
You're straight out.
I
Mm-hmm.
mean, you know, the children straight out.
Right. Appreciate it.
Yeah, but it will cost you,
Yeah.
and that's the hard part. If we had registered land, it's so easy to do it. Because you go to any attorney now, he's gonna do the same thing we'd be talking about now. Okay, so there was a will probated. Let me see that bill. So he's gonna go to the registry to get that bill. Then he's gonna go to get the registry to the one before, because he's gonna have to be checking this wording.
Right.
And then yeah, it's just a lot of work before he even decides to say split it between A and B. It is a lot of work.
Yeah.
It's a lot of work. Anyone else have questions? This is a very interesting topic, eh? Land law,
Yes.
especially in the Bahamas.
Hmm.
Yes, it is.
Especially.
Miss Archer, I had a case one time at work where it was a client and they built on the wrong property. They actually
Oh, I hear
built
about that often.
they built actually on, as I guess it was two brothers, and his daddy gave him his property, but he actually built on the uncle's property. And I think the uncle had passed away as well. And of course he had siblings, I mean kids, who I guess, and the situation was where it was a foreclosure situation. And of course, I guess from the buying's perspective, that's the title isn't, well, what do I want to say? I guess sort of like a title defect, I guess you would say,
Mm-hmm.
because technically you actually came to borrow money for a home that you actually built on the wrong. I don't know how to describe it, but the house is on the wrong property. And
Right.
how it was, I guess we were trying to see how best we could assist the client. And the situation was where the client had to actually go to his cousins to get permission to, I guess, they call it a transfer or something like that. I'm not sure the real terminology, but it's, I guess, a transfer of land or something like that. I'm not sure of like the terminology that should be used, but it was
So he gave his property, transferred his property to them, and they transferred theirs to him.
Right, but the complication
Uh-huh.
was they weren't in agreement, and of course that
Oh,
was
God.
legal. That was legal work, and they had to get like consent and, like you said, affidavit signed to say that I am allowing permission for this transaction to happen. It was very complicated,
Oh,
and
nice.
I
I
always find that when it comes to land, people never agree.
The worst situation.
Everybody
to
agree
deal with.
before the death, and once the death occurs, people don't agree anymore. Everybody's looking to who could get the most out of it. Yeah, but I've heard another story where two ladies purchased property the first time. Come to find out after they had made quite a few down payments, the supposedly supposed to be owner of the property disappeared with all the money.
Jesus.
They were paying it directly, not to an attorney, paying it directly with the person, thinking they were getting such a good deal. The person disappeared. The second time they went again to try to see if they could build a home. The contractor built a home on the wrong property.
Wow.
Yeah.
Oh,
So there are a lot of horror stories out there when it comes to land. A lot. And again, I say it's because our land is not registered. I don't know when we will move into the 21st century. I know it's a way to make money in the legal profession, but this way is really archaic. It really is.
It's so sad because I've seen where conveyances were done, the 30-year root title was search was done, everything was signed, and then 15, 20 years later, somebody challenges the the property, and it's held up in court. It's banks are involved, and it's just a mess. I mean, we have
Yeah.
I know of a case where, similar to what Pintard was describing, we had a case where a lady died and left a house to her two sons, tenants in common. One of the sons died, and so his children, even though they were not lawful children, they were his children, gained 50%, but they were tiny. They were like 3 and 5, something like that, right? So the uncle or the other brother saw that he was acting in the best interest of the children because the mother of the children had gone to prison and the children were still out, but they needed someone to take care of them. He acted in the best interest of the children by selling the house, giving them their 50% once they paid the medical bills for the other brother, gave them what was left, split it between the two children. Now that the children are adults, they are challenging whether the uncle acted in their best interest when he sold the property. And so now it's a mess. Somebody bought the house, the person who bought the house now can't do anything with it because technically the brother was only entitled to 50% to sell. The children are saying that he didn't act in their best interest when he sold the house and whatever was left for them, whatever monies they got. So, it's just a mess. It's a mess. People could come and challenge your property 15 and 20 years later.
Yes, they can. Yes, they can. And that's the thing about it. I know of another issue. It involves land too. So, husband and wife, right? Wife dies. The wife had property. One was the matrimonial home. The other one is vacant land. So after the wife's death, the husband sold the matrimonial home, got the money, paid off whatever small balance was left on the loan, took the rest of the proceeds and spent it. the vacant property was used as collateral for the matrimonial home, and the husband never went to the bank to finish the transaction after the loan was paid off. So the bank is holding the property, and the proceeds from the matrimonial home they have spent. And I told them, I said, when that child reaches the age of 18, you have a duty to account. You're only entitled to 50% of the proceeds of that home.
I was gonna ask if they had children. Mhm.
Yeah, you only entitled to 50%. I said, what did you do with the other half? I bought her a laptop. I say, well, anyhow, pray she doesn't meet the wrong person who tells her what her rights are. Because you're gonna have to find that young lady's money.
Wow.
I said, and the property itself, 50% is yours and 50% is hers. And I don't think you should let the bank hold on to those deeds that long because the property is very valuable. So they're not interested.
What?
Yep. 2 acres.
Jesus. Mm-mm.
2 acres.
I have a question as well, just clarity.
Go ahead.
Does the freehold interest has both, you said both legal and equitable interest? Is that correct?
Yes.
Another one was real property is both tangible and intangible items, right? But can it be further broken down into two, meaning the choices in action and choices in possession?
Yeah.
Okay, I just was making sure.
Okay.
I mean, what I'm basically getting at is the fact that certain wording is almost the same thing. It's connected.
Yeah.
So
Yeah.
it's sort of confusing. So I just wanted some clarity on it.
Oh, okay.
Mhm.
Yeah, it is. But you could see with the whole land issue in the Bahamas, it is just, I mean, it's just open to dispute. You really don't know sometimes who actually owns the land. You just don't know.
Yeah.
Ms. Archer, I had a quick question with some persons who go into these rent-to-own agreements. How does that work from the conveyance standpoint? Because if a person is paying, like, let's say, paying an agreed amount on a monthly basis, that can't be conveyed over until it's the I guess the value that they were looking for is completed.
No, so what are they doing? Paying you monthly to own it?
Rent to own, yeah. You know,
Rent
you
to
hear some
own.
people having that agreement,
Well, you can't convey it until it's completely paid.
So would that person, the renter, be protected, like, I guess, in whatever lease is drawn up between the person that they're renting from, between the two parties?
What you mean protected? How?
Right, like if they invest for maybe 5 years, I don't know, let's just say they get close to the point where they could, if an agreed amount was set and they get close to that amount, could the person who got into that agreement with them at the onset pull away? How is the renter protected in any way in that scenario?
Oh, okay. So that's again comes back to what we talk about the terms and condition. So when you draft your contract, if you are the renter, you need to make sure that there's adequate provision in there for such instances. So that's why they always say when you get a contract, you always let a lawyer read it. So they'd be able to interpret the provisions for you because it may not be included. So that's why they always say let a lawyer look over a contract and they'll be able to ask you questions like, okay, so what happens if you pay half down? What happens if you pay 3/4? What happens if the person dies? All those kind of questions you look to see if there are provisions in the contract to address any issue. So there are standard clauses and then there are other things that you need inside the contract.
Okay.
Could you sign a contract from the lawyers and then go back and say, I would like to see the contract for another lawyer to read it over?
When you could get more than one copy from the beginning. You make the lawyer feel like you doubt their work.
Yeah.
So it's simpler for you to just get more than one copy from the very beginning if that's how you feel. And give it to more than one lawyer.
Gotcha.
Yeah. You don't wanna have people having bad feeling. That's not a good thing to do. Yeah, so far so good. You all are tuned in and excited. I love it. So next week we're going to do module 3, which is different types of mortgages. And I know my mortgage people will know this one very well. On the 4 types of mortgages, the different types of mortgages, and the reliefs that are available. Any more questions? We're good?
Good.
Very good.
Okay. All right. That sounds good. So for the next module 3, if you have a chance, if you can start to read some of the cases at the back. At the end of the module, I have some cases there
Okay.
to do with remedies.
Okay.
Okay. So if you start to read those, then when I ask some questions, you'll be more familiar. Okay.
Are you going to stick the questions in the back of the module? That's primarily the questions that you'll probably be asking at the
For exam?
Mm.
Oh no.
Oh, Jesus.
No, most definitely not.
You can't
That's
hear
too
Ms.
easy.
Ms. Archer have a plan for us?
Of course.
Yeah.
I need to record this thing and sleep with this on my head.
Why? Hold on. Someone
Listen.
asked me a question last class, I think. Someone put quieting title about how long what's the length of time? Like if someone quiet your property and then they put in an application.
You mean put it in the paper? How long?
Mhm. Yeah, how long? Right. Okay, so they have 30 days.
Gee. Okay.
30 days, yeah. So I found one in the paper this week. This one was the quieting title, the petition of Jeffrey Stewart Thompson of number 104 Lincoln Boulevard. And he is asking for all that lot of land, number 30 in block 29 of Engliston Supervision, containing an acre of 8,923 square feet, more or less, situate on the southwestern junction of Balfour Avenue and Lincoln Boulevard, bounded on the north by Balfour Avenue and running thereon 96.08 feet on the east of Lincoln Boulevard. So Jeffrey Thompson is saying he claims to be the owner of the fee simple estate in possession of the said land, and he has applied to the Supreme Court under Section 3 of the Quieting Titles Act to have his title to the said land investigated and declared in the certificate of title to be granted in accordance with the provision of the said act. So let's just say no one comes forth and then the court grants it to him. And then let's say 2 to 3 persons down from now, someone purchases this land, it will stop right here to this quieting, right here. So whoever owned it before, it's long gone.
And they only give them 30 days?
Notice is hereby given that any person having dower or any adverse claims not recognized in the petition shall within 30 days after final advertisement of this notice file in the registry and serve on this petitioner or on the lawyers a statement of their claim.
So really, what is the person who is inquiring about it or wanting this claim? What is their process? And then how is the person who actually owns the property is supposed to respond? Right in the paper or?
No, they have to put in a claim that they're the rightful owner.
Right, to the attorney or
To the attorney, verified by an affidavit.
And then what they do to inform this person that it's, I just trying to say, if I put in the paper now and I'm asking, you know, for claiming this property, how will I get my response? What would the person do? I'm saying, do they go, you're saying go to the attorneys and then attorneys will then respond? I mean, I trying to figure out.
Yeah, you'll have to go to attorney and go to your attorney and say, hold on, I have the fee simple absolute in this property.
Right.
Here's my title deed. Write to these people, and then this action will be stopped.
Okay, gotcha.
But if you don't, this person will get their certificate of title.
Sure.
And so that's what I was telling you all in the first class, you must read the local papers, even though they be.
So Ms. Archer, is there a law or a list of criteria, conditions that will allow somebody to make an application? Like they'll have to be on the land for X amount of years or something like that? Is that it?
Yes, all of that.
Wow. So what if they don't qualify? Can they still, like, let's just say they met 8 of 10 of the criteria. Are they still able to make application?
You have to meet all the criteria.
Oh, you have to meet all and show proof of it.
Okay, so he's making his application under Section 3. So Section 3 says any person who claims to have any estate or interest in land can apply to the court to have his title to such land investigated and the nature and extent thereof determined, and unless the court, and in a certificate of title to be granted by the court in accordance with the provisions of the Act. So he can do it under Form 1. If I could get you Form 1. See, you have to be careful of these things because this is how land more or less disappears. So in your petition, so this same man, Mr. Thompson, he would have filled out a form that he owns this in fee simple absolute, like I just read to you, right? And then he say that there is no charge, no encumbrance, dower, or right to dower affecting his title to the land. And what else he say? Except that, or that Mr. Thompson title is subject only to the charges and encumbrance and dowers or rights or to dower mentioned in the schedule here too. And that the only persons having or claiming any charge or encumbrance of estate, they need to let him know. And then he prayed that his title to the land may be investigated, determined, and declared under the Quieting Title Act. So this is why he's saying you have to read the paper.
Another question is actually, because I heard of an instance where a person did not know that they had acquired property. When I say acquired property, sorry, they were inherited property until like many years later. But at that time, like you say, someone else had acquired it. There is no type of, there's nothing that they can go on to say, well, I did not know until now.
No, how you could do that? And when you publish the notice in the paper, that is notice to the whole world.
Wow. And so the ignorance is an excuse, I guess.
No. Remember, I told you that happened to someone who I knew who had acres of land on Turks and Caicos. They lost it all. Then there's nothing they could do.
But I thought, I mean, not that I thought, but when you said that example, I said that was in Turks and Caicos. I wondered if I was.
And they have registered land.
Oh, there's even more organized than us.
Yes, they have registered land.
Oh, they have registered. Then they need to get our land registered, man. That will alleviate a whole lot of problems.
Yeah, because if you saw a piece of land right now and you wanted to buy it, you'd be able to go and find out exactly who owns that land.
Yeah, that makes life a whole lot easier.
Mm-hmm. That's what they think.
But 30 days is really not enough notice, though. I mean, people don't even, I don't even read the newspaper no more.
No excuse.
30
No
days, still.
excuse.
They should put it on TV. We stop.
Yeah, so you'll have people like I was telling you. So you have your piece of land, right? And next to your land, from the time you moved there, nobody was there. So all you do is you just put a little gate there and you start farming your little peas and whatever. No one came to say, hey, I own that land. Remember, I told you, whenever the owner of that land comes and say, excuse me, what are you doing on my property? Time stops. So then you'll have to start over again and pray he don't come around. But if nobody comes around and the time has passed, you put in your claim.
That's risky. So,
No, it ain't risky. You just may be lucky.
which is true, but then, like you say, the person might actually come, and then you say it starts all over again. So, in the process of them coming, they can't get that person off the property.
Yeah, you could get the person off because the time hasn't passed. So you need to say, hold on, pick up your peach trees and move. This is my land. I have papers to this land. If I see you here again, I'm going to call the police.
Do you know what the time frame is for that?
No, hold on. I can't remember how much it is. Hold on, let me think.
10?
Wasn't it like 12 years?
I thought it was 10.
No, it's 10 or 12.
I think it's 12 years.
Yes, 12. 12 years.
So you have once you could provide proof that you had possession or you occupying this land for 12 years, you can go and apply for.
Yes. Uh-huh.
Wow. Well, so what if you know the owner? Can you still go ahead and do it? Like, it doesn't matter what your relationship is with the real owner?
The relationship has nothing to do with it. It's whether or not the owner of the property came and said, I am the owner. So when you put in your claim, you have to say, this is your plan of the land, right? You have to be able to give a description of the land. You could have an aerial view of the land over the time that you occupied it. Of course, someone else could come and say they own the land. And then the identity of the last known legal owner against whom the possessor claims. So you claiming that you are the last legal owner of this property. People do this all the time. They're always in the papers.
Can non-Bahamians do that as well?
No. That's impossible.
Okay.
No, it's normally done by Bahamians.
So, Ms. Archer, that's why they have so much issues with the property in Abergawe.
You mean after the hurricane?
I mean, even before the hurricane, where there was a dispute over the land because the persons won the land for so long and they claim it was theirs.
Well, those persons claim that they have a piece of document that was given to them by their employer. Now the question was that was supposed to go to court to be decided as to whether that paper itself is valid. That's the question. Was it valid? Because to transfer land, like I told you, you need a conveyance. So if I just take a sheet of paper and say, I transfer to you my 1 acre of land on Robinson Road between this street and that street, that is not a conveyance. It has to be done by deed. So I don't know if the document that they are holding is an actual deed. Then you don't know if the person who gave it to them, who was their employer or owner, whatever one they were, whether or not they actually had a title in fee simple absolute in possession for all of the land that they actually sit on. So there's a lot of questions to be answered before you could say, yes, they own that land. Or because they've been sitting on it for so long, they own it. Because if it was owned by others, they may have been going there very often saying, this is our land when you're going to move. So the quieting would have never taken place.
So just to be clear, if somebody started to plant like trees or something on your property and you come there, just say you dig up the trees yourself, the 12 years then starts
No,
again,
you have to tell the person. You have to tell the person.
or you have to tell the
The
person.
person. You have to tell the person this is my land.
Mm. And so
You can't
once you
just go
tell the
and pull it.
person,
Time stops.
time stops and then it'll have to be another 12 years
Start
again.
again the next day. Yes.
Oh, okay.
So what if they
That's
say
pretty.
that I never came to them and tell them that it was their land? Is there?
That's why you need your evidence.
You
See,
better
the
record
minute,
it.
That's why I
yeah,
say.
yeah. The minute you see someone on your land, you go and you say, guess what? This is my land. I own this land in fee simple absolute in possession. I own this land. You go to your attorney and you make a note. Mr. So and so, adjacent my property. Here's his picture. Was planning on my land, and I advise him this is my property. Here's my recording.
Okay.
Time stop. So even if he missing, put that in the paper. Sue him.
I like that.
But I've heard of a gentleman or a guy that actually does that for a living. Just quiet in land.
Mm-hmm.
Mm-hmm.
Yeah, because the people are not reading the papers. I'm telling you, it
Exactly.
will be gone.
Especially like those I guess the generational ones,
Yeah.
like on the family islands where
Mhm.
everybody is moved to Nassau, grandparents died, everything.
Yep. I know of one. It wasn't a quieting. It was this elderly gentleman. He had quite a bit of beachfront property on a family island. Some foreigners came down because some Bahamians, blabbering them out. Oh yes, yes, plenty property down here, beachfront property. Go see Papa Sue. So the people flew down, came, offer him $75,000 for 5 acres of beachfront property.
$75,000.
Yes, ma'am.
Oh, Lord of mercy.
He was so happy to see that money. He took it.
Wow.
Yep. And the government had to step in. I had to go and look for those gentlemen. I was fraud. Told the old gentleman he have to give the money back.
Wow.
The government literally had to step in. That was like raping and robbing. That like with your eyes wide open.
I'm serious.
Yes, it was. Yes, it was.
So, Ms. Archer, I actually have a personal situation where there's a small piece of land in front of my home. I live like at a dead end. Man, don't laugh. Ms. Archer, don't laugh. I live at a dead end. And there was a lady that was here before we started to build. And she was saying that she had some issues with the developer and that was supposed to be a part of her land. So me being, I guess, naive and stuff like that, we never used to really bother it. So she would, when she get her lawn done, she would, you know,
Moet.
mow it.
Mm-hmm.
And then recently during the pandemic, a development started on the other side of our home, and me and my husband got concerned about our boundaries. So he's like, let's get a surveyor to survey the land. I got my documents. Well, the surveyor actually got like the plot plan from the register, I mean, from Lands and Survey. And then I gave her my conveyance to show what exactly laid out, what was laid out in my conveyance. And it didn't really give specific details of 500 feet east, southeastward, or anything like that. Didn't give any details on that. So she said, well, whatever Lands and Survey says the size of the property is, that is what it is. So she started to put the stakes down, and my husband came in when he was like, "Oh no, don't let her do that. That's that lady property." But I said, "But she said that's ours, baby." You know.
Uh-huh.
So I a little paranoid now because I've been here. Like my son is 10. My son is 10. I think we moved here like when he was like 2, 3. So do I need to like? What do I need to do in that case? I, because I mean it's a very small piece of property and it's very tiny, but it's in between our homes at the dead end. So she normally gets it mowed whenever landscaper comes. you know, but the stake that our surveyor put down is actually beyond that, more into her yard now. So,
Okay. So
Wow.
you need to let her know that you own the property.
okay, okay.
I'm curious,
Let her
what you
know.
call a small piece of land?
I
It's,
was gonna ask her
Like
that.
25, I don't know.
I don't,
25A.
maybe like 25 by 25 or something. It's very small.
I still get much.
And
Yeah.
that's what I want to say, because I can like extend my home and move forward
Yeah.
that way or
Yeah,
something
You
yeah.
put a
like.
nice gazebo on that.
Like
Yeah. That's a good
about
size. Yeah,
And like,
you need to put your stakes down and you let her know I own this land. There's no need for you to mow it anymore.
yeah. Yeah,
war.
okay.
War.
Yeah. It ain't gonna be war. She does have to let her know.
Okay.
Because if that's what it says on the thing, that is what it is. It is what it is.
But when you would have purchased the land, I mean, it wouldn't have had that, in your.
Sometimes the conveyances, from my experience and what I actually saw in my conveyance, sometimes the conveyance can be vague. It would say a plot of land located Nassau Village. It wouldn't say, well,
What on
50
the
feet,
south, what on the port?
right.
Yeah,
It wouldn't say
yeah.
like 50 feet southward of property owned by Jane
You didn't get
Doe.
appraisal.
Right. So the appraisal actually gets the
They,
the plot plan
mhm,
this from the lands and survey.
right.
So I know when I first got the appraisal done, the guy was like, this property is yours. I say, but the lady was like, oh, when she got hers, that was originally supposed to be hers and her and the land. But the purchaser, the vendors like in dispute of the dimensions of her property and
Oh
stuff like
Lord.
that. So like,
Now remember, another thing you have to remember too. When certain areas of land are first sold, the plan could have been there were dead ends. And
mhm,
then over time, the government changes and opens it up to a road.
mhm,
You see? So that's why you always have to check to see where your boundaries lie. Because it could have been when you first purchased it, it ended there. Hers ended where it was, and that was a vacant piece of land. But if they would have opened the roads, then the measurements change.
mhm.
Because they're not gonna have a little slip of land sitting by itself.
And even too, like when we first moved in, the person that we purchased the property from, they actually had the stake. It wasn't where it is where the surveyor recently placed it. So I just was assuming, you know, well,
Now
it
that
is what
person
it is.
probably might have even put that down wrong. You never know. In
Well,
those
that's
days,
true.
when people didn't go to school,
That's true.
they put it down wherever they thought it should be. They wouldn't know.
Well, I mean, this is a fairly new subdivision. And I
Mm-hmm.
even remember when the guy came and he did the boundary markers right before we moved. I remember when he was doing that. Like, I actually remember speaking to him and I had this guy looking at everything, and where he placed the stake in the corner compared to where the new surveyor placed the stake. It's like it's beyond our property, almost in her yard, like
Mm-hmm.
almost close to her driveway.
You
You
better
know,
start planting plants.
Yeah, but you need to go and tell her that's her property.
because we want to
Mhm.
actually enclose our property, so that's why we got.
I'll tell you another slick thing what they like to do. Let's say the two properties are together. You
Mhm.
don't have a fence in between, right? So
No.
know what they like to do? They like to put their garbage tin on a piece of your property. So
Oh,
that when they intend to run a fence, they're taking a little slip of your land because they're going to put the fence to run from the end of the garbage bin
right.
and run it back. And then they take a piece of your land once they fence that in. And if you're foolish enough not to know where your boundaries stop, piece of your land is gone.
Mm.
Oh Lord, you can me have a nice conversation with my husband tonight.
Yeah, but
Gotta
that's why
know.
they have a difference between an appraiser and a quantity surveyor. They very
Yes.
different, and you have to make sure it's very, very few quantity surveyors. There's only a couple of them that are qualified to really say what the measurements of a property are. An appraiser has an idea, but
Hmm.
the quantity surveyor is really the right person to tell you what your boundaries are,
Mm-hmm.
what the size of your property.
Right.
Don't let them get away with that.
I have a personal situation as well too. My husband and I just purchased some property, and I had it cleared down. I think the beginning of this month or last month, and the guy who's in control of the tractor say, I see where your stakes are, and the neighbor on the side of you have cabbage and lettuce and stuff on your property. I wondering what should I just put up a fence one time, even though they have it a little bit on my property.
Yeah,
So
but are you going to build?
I am.
So why are you hurrying up to put the fence? Go and tell the people you planted on my land. Please move unless you want me to reap the harvest. It's as simple as that.
You say you have lettuce now.
Exactly. Just letting them know.
Yeah. Okay.
And you have to be stern, because if you allow them to get away with it, they will continue. Some people are like that. Some people will say later down, they may say, oh, you were very rude and this, but you have to, when it comes to land, you have to set it straight. This is my land. Don't plant on it. Ask my permission first.
Right.
Let them know.
Okay.
People will take it over. Next thing you know, they'll run a fence when your house finished, and it'll include part of your land.
So, thank you.
So because you do not intend to put the fence up until you finish building, you go across to them and say, I have noticed that you plant your vegetables in my yard. Should I assume that you want me to reap the harvest, or are you going to pull them up? And then they say, no, you don't need to do that, miss. You can have it. You never know, but you just letting them know.
Right. Okay.
I had one last question on
Go ahead.
quieting of land. Can someone quiet your land if you're still paying the bank for it?
No. Mm-mm.
Okay.
But you see, that is why you, as a potential owner, need to read the paper. Because what if when that person say they're quieting the land, they knew that the person who had the fee simple absolute is dead, and you here paying the land from somebody who don't really have the fee simple absolute in possession. Like I say, our land is unregistered. Everybody around here holding papers say they own land.
But I hear what you're saying, but if essentially the bank owns it.
Yes,
because
but
you're
don't
still
forget now,
paying for it.
Yeah, but don't forget, I told you there are dubious lawyers. So yes, you may have a mortgage, but that doesn't mean that you have a free title, a free and clear title.
I hear you.
Not to mention, you have lawyers who don't never register the property.
Oh, that's true too. Yep, that too. That's why I just call them dubious lawyers. They take the client's money, but they don't register the property. All of that you have to be mindful of. So again, from my first class, please read the papers.
Yes, ma'am.
Please read the papers, because your property will be taken from you right in front of your eyes. It will. And then you'll be trying to battle for something that you can't get back. Yep.
So what happens now if the lawyer didn't register your land? You got me sorry.
You're going down a really slippery slope.
I gotta go find out. What else? All I can tell you is make sure, go to the registry and make sure that it is, because if you know the amount of attorneys that have not, and I'm talking about all levels, all junior attorneys, senior, huge firms, property not registered.
Yep.
Okay. Thank
There's
you.
a lot. There's a lot. It's a lot. And then, like we say, some attorneys have been disbarred for that.
Like what happens too, right, Ms. Archer? The client now has to have a civil suit against the lawyer because there's nothing they could do. I mean, it
exactly, try to get their money back.
Exactly. But so the bank, will the bank who is who has security on the mortgage, They won't get into it at all, though? I mean, seeing that that is part of their security.
Yeah, they try on a one-on-one basis to see how they can actually have their security registered. And they have to do them on a one-on-one basis. I know of some banks that were trying on a one-on-one basis to have their security done, had to hand it over to another attorney and try to see if they could have it registered. And that means that the bank had then had to pay that cost. So they incurred a loss. Well, losses. Because it depends on the attorney. They may have had about 20, 30 cases just from one attorney. So it's a costly thing. That's why I'm saying whenever you have land, please read the papers. And if you have land, you need to go and visit your property. Walk on your property. Go with your cutlass, put on your long pants, and walk through your property. You may find when you get there, there's someone in build a hut on your property in the middle and you didn't see it. So all these things is food for thought. All right. So we're good now. All questions done. Y'all can go to sleep tonight. Some could speak to the neighbor. Some could pull up the vegetables.
Yes,
Some could
ma'am.
extend the fence.
Man, I weak.
And some gotta check their papers.
That's
Yeah.
right.
Directly.
All of that has to be done.
All
So,
right, thank you.
all right. So have a good night. And I will chat with you all next week.
Okay.
Okay. All right. Night.
Thank you. Good night.
Good
Okay,
night, good
night.
night.
Okay.